Article 223 of the Revised Penal Code is your conniving with or consenting to evasion, otherwise known as infidelity in the custody of prisoner. Let's go to the elements. Number one is offender is a public officer. The public officer has in his custody or charge a prisoner. That prisoner is either a detention prisoner or a prisoner by final judgment. Number three, the prisoner escaped from his custody and the public officer was in connivance with the prisoner in the latter's escape. So let's go to bar exam questions para maintindihan nyo. So there was this chief of police. He believed in good faith that a prisoner serving a 10-day sentence would not escape. So he allowed said prisoner to sleep at his house because the jail was so congested and there was no bed space available. So accordingly, that prisoner went home to sleep every night but returned to jail early each morning until the 10-day sentence had been fully served. So is that chief of police guilty of any crime? Answer is yes. The chief of police is guilty of Article 223. Bakit naging guilty? Because according to a case, ang sabi ng Supreme Court, if there would be a relaxation of imprisonment that is considered infidelity, it would make the penalty ineffectual even if the convict may not have fled. Still, it violates the provision of Article 223. Another bar exam of similar nature. So there was this town fiesta, or during a town fiesta, A, the chief of police, he permitted B is a detention prisoner, and his compadre to leave the jail and entertain visitors. Entertain visitors in his house from 10 o'clock in the morning until 8 in the evening. But B will return to the jail at 8:30 p.m. So question, was there any crime committed by the chief of police? Answer is yes. A committed the crime of infidelity in the custody of a prisoner. Ano ang sinabi natin? If there would be a relaxation of imprisonment, that would be considered infidelity. It would make the penalty ineffectual. Kahit sa problem na ito na bumabalik si B sa municipal jail at 8:30 p.m., that is still violative of the provision of Article 223. Before we go to other bar exam questions, let's read Article 157. What is Article 157? That is the evasion of service of sentence. Kasi pag tinatanong ito sa bar exams, itong infidelity in the custody of prisoner, palagi yan, most of the time, hindi naman all the time, but most of the time kasama palagi si Article 157. So, again, what are its elements? Number one is the offender is a convict by final judgment. Take note ha, the offender is a convict by final judgment. Hindi ito detention prisoner. Number two, he is serving his sentence which consists in deprivation of liberty. And number three, he evades the service of his sentence by escaping during the term of his sentence. That is why evasion of service of sentence, umiskapo. So, sampulan natin para mas lalong maintindihan. So, there was this person, X, he was serving a 6-year prison term. So, 4 years na siyang nakakulong, but he discovered that the judge committed a mistake in giving him a 6-year sentence. Bakit? Because nung binasa niya, he found out that the law he violated called only for a 3 years imprisonment. So, there is this jail guard, the name is Y, and he is also a law student. So, he checked the contention of X and he found out that it is correct. So, X did not want to go to court anymore because first, he does not have the money to hire a lawyer to file a habeas corpus. Second, he lost faith in the competence of judges. So, what did X informed? X then informed Y that he would just escape and Y did not object. So as soon as Y turned his back, X ran out of his cell. So what crime was committed? Answer is, as far as Y is concerned, Y the jail guard, he is liable for infidelity in the custody of prisoner. How about X? X is liable for evasion of service of sentence. Yun ang sinasabi ko na minsan or most of the time magkasama ang evasion of service of sentence and infidelity in the custody of prisoner. So let's go to Y, the jail guard. Why is he liable for infidelity in the custody of prisoner? Because number one, he is a public officer, and in his custody, being a jail guard, he has in his custody a prisoner who is serving by final judgment, and the prisoner escaped from his custody, and Y or the public officer was in connivance or gave his consent with the prisoner in the escape of the latter. That is the reason why the jail guard in this problem, or Y, is liable for infidelity in the custody of prisoner. But how about the allegation of X na ang sabi niya, dapat hindi 6 years ang pinataw sa akin but only 3 years? What is the presumption of the law? There is that presumption that the sentence which by final judgment which was being served by X is correct. If the court committed an error in sentencing him to an erroneous prison term, then you should remediate according to the law. You cannot take the law into your own hands. The remedy is not to commit another felonious act. So another bar exam question. Here is Chito. Chito here has a brother. The name of his brother is Willie, and Willie is a detention prisoner. He also has a cousin, Vincent, and Vincent is serving sentence for homicide. So ano ang ginawa ni Chito? Chito gave 50,000 pesos to the clerk of court. Bakit? Para si clerk of court will issue an order requiring that, kunyari, his brother and his cousin will appear in a case as witnesses. So the clerk of court issued that order, but the clerk of court forged the signature of the judge and delivered the order to the jail warden, who in turn allowed his brother Willie and his cousin Vincent to go out of jail, but in the company of Edwin. Armed escort si Edwin. Si Chito also gave the amount of 50,000 pesos to Edwin. Ano ang gagawin ni Edwin? He will leave Willie and Vincent unguarded for 3 minutes, and it will provide them with an opportunity to escape. Therefore, Willie and Vincent were able to escape. So, what crime or crimes, if any, had been committed by Edwin and the jail warden? Answer is, as far as Edwin is concerned, the jail guard, he is guilty of infidelity in the custody of prisoners, specifically conniving with or consenting to evasion, for leaving unguarded the prisoners escorted by him and providing them an opportunity to escape. He is also liable for direct bribery for receiving the amount of 50,000 pesos as consideration. How about the jail warden? The jail warden is not liable for any crime. He did not commit nor incur a crime because according to the facts, walang statement in the facts that would show that he is aware of what his subordinates are doing or are planning. So he is not aware of what his subordinates had done, nor of any negligence on his part that would amount to infidelity in the custody of prisoners.